So today we're talking about the very, very fun topic of adulting. And I know a lot of you are like, what does that even mean? And I honestly sometimes don't know myself at 35 years old. I will say, disclaimer, even though the title is adulting and getting your shit together, after this presentation, you still might not have all of your shit together. This is just the first step, and that is okay. I find that with most things, it's just one step at a time. We'll take all those steps one step at a time together. So a little bit about me. My name is Stephanie Louie. I'm originally from Los Angeles, California, and we moved out to Texas a few years ago. It'll be 3 years in September since we officially became Texans. We love it out here, much better than California. My family, I have a husband, I have a dog, I have parents, and I have a sister. I did have a son. He was born about 3 years ago, but he did not make it. He passed away shortly after being born, which was one of the impetuses for moving out to Texas and kind of having a fresh start. One of the things that I find has been helpful, I guess, in doing the work that I do is that I really understand the pain that death can bring to a family. And it's terrible, but it's something that happens. It's part of life. And so we just have to be prepared for it. A little bit about my education: UC Berkeley, go Bears, University of San Francisco School of Law. I am a former litigator, which means I used to argue in court all the time. But my husband told me that he didn't want me to do litigation anymore because I was always picking fights with him and coming home angry. So I switched to estate planning, which there is no yelling in estate planning, which is amazing. People are much happier for the most part. So it's a much better area of law to practice in my opinion. I think if some of you have been at some of the other Zoom meetings, we've talked about superpowers before. And one of my superpowers is that I'm really, really good at making songs about my dog. I will play one for you sometime if you're ever interested. But yeah, that's my superpower. And a fun fact about me, I am a legal midget at 4 feet 9 inches tall. Yay! I could technically get one of those disability placards, but my dad's always like, you're not actually disabled, so you leave those for the people who actually are disabled. And I'm like, but there's no parking, so I should really get one. But I don't have one yet. Maybe when I get older. All right, so adulting. Do I have to? Unfortunately, yes. You become a legal adult, at least in the state of Texas, at 18 years old. I think most of us are probably past that age, maybe just a little bit past that age. But I think most of us are over 18, and that is pretty much the standard for what a legal adult is in most states. There are a couple of exceptions. Alabama and Nebraska, you only have to be 19. In Mississippi, you have to be 21. And some states say that you have to be 18 or upon high school graduation, which I feel is very strange, because what about those people who graduate from high school early? Like, I don't know if anybody's watched Young Sheldon, but he graduated high school at 11. That's like crazy. I don't think he would actually be considered a legal adult at the age of 11, even though he graduated high school. Anyway, so that is the definition of what a legal adult is. It's just a matter of age for the most part. There is a difference, though, between being a legal adult and being a legally competent adult. A legally competent adult is one who has reached the age of majority, again, the age of 18 in Texas, and who is of sound mind and capable of making decisions for yourself. So in other words, you have to be able to make your own financial decisions and your own decisions about your health care. And that makes you legally competent. And there are different standards in the laws kind of determining how you you actually are like, oh yes, I am capable of making these decisions. But I think for the most part, you understand that, hey, like if you have all your faculties, if you know who you are, if you can generally make good decisions for yourself, then you are competent. There's another legal definition, a legally responsible person. And this is somebody who has a legal obligation under the provisions of state law to care for and make decisions for an individual. So for instance, if you are not a legally competent adult, but you are an adult. So let's say you're over the age of 18, but you're not for whatever reason competent, you still need to have somebody who is going to be legally responsible for you. So that's what we're really talking about today, is how do we make and appoint people who can be our legally responsible persons if we as adults, for whatever reason, lose our competency. So these are what we're talking about. Again, it's decisions all adults have to make. One is decisions about your person, all matters relating to your body. So healthcare, where you're going to live, what you're eating, how you're going to dress, anything that has to do with your body. We call that making decisions about your person. The second kind of decision we have to make is about our estate or our money. Anything related to your finances is called an estate. So when you are a legally competent adult, you get to make decisions for yourself regarding your person, your healthcare, where you live, what you eat, what you wear, all of those things. And you get to make decisions for yourself about your money, how you spend your money, what you keep your money, how you make your money, all of those matters. If you are not a legally competent adult, somebody has to make those decisions for you. And that person is called a guardian. So a judge will actually appoint both a guardian of the person, someone who's going to make decisions about your body, and a guardian of the estate, someone who's going to make decisions about your money. So I don't know why I put Pikachu on here. I was getting bored and I just wanted some color on these slides. But essentially, as I was saying, as competent adults, we get to make these decisions for ourselves. And we also get to decide who is going to make these decisions for us if we can't make them ourselves. This is called appointing a power of attorney. So it's choosing somebody to act as our agent if for whatever reason we can't make these decisions for ourselves. So it's like choosing a Pokemon, saying, you're the one who's going to be making decisions for me. As opposed to if you don't appoint somebody who's going to be your power of attorney, a judge is eventually going to appoint somebody for you. And these are called guardianship hearings. It's literally a hearing in public court where people who are interested in being your guardian, usually some family member, will come forward and say, I want to be, responsible for Steph because she's lost her mind or she's in a coma or she can't take care of herself one way or the other. And the judge, who doesn't know me, doesn't know my family members, doesn't know anything about what's going on in my life, has to make a decision as to who is going to make all of these decisions for me. Not the best way to do it, just in general. So if you can avoid having a judge appoint a guardian for you by choosing your own power of attorney, that's a much better option. So when we make these choices as to who is going to serve as a legally responsible person for us, typically I call these disability documents because they take effect during your disability. Disability meaning when you do not have the ability yourself to make decisions about your body or about your finances. So there are 5 different disability documents in Texas that estate planners will typically prepare for you if you are having them prepared by an estate planner. The first is a HIPAA authorization, which has to do with granting certain individuals authority to access your private healthcare information. HIPAA generally, we'll talk about it a little bit more. It's especially important for young adults, people who are like, say, in college, to have a HIPAA authorization, because if you have a young adult who goes off to college, let's say they're 18, so they are an adult. If they go off on spring break vacation, skiing or whatever, and they get into, some kind of terrible accident and they're in the hospital, if you as their parent are not listed on their HIPAA authorization, legally and technically, the doctors at the hospital are not supposed to talk to you about what is going on with your child, even though you are a parent. So you do want to make sure that you are on that HIPAA authorization, so that if anything should happen, God forbid, you will be able to speak with the doctors legally about what's going on with your child's medical issues. We also have medical power of attorney, which is the authority to make healthcare decisions. You're appointing somebody to make healthcare decisions for you. The durable power of attorney is appointing somebody who's going to make financial decisions for you. Declaration of guardian is really just a backup to the powers of attorney. It's so that if, for whatever reason, your powers of attorney get lost, or you somehow revoke them by accident, the judge has an idea, has this list of names of people who you would want to name as your guardians. And then the advanced healthcare directive is you're appointing somebody to make end-of-life decisions for you. Okay, so that was just a basic overview. Here's a little bit more detailed information about the HIPAA document. It is a federal law, so it's not just applicable to Texas. Anywhere in the United States, healthcare providers are supposed to only allow people access to your private healthcare information who are listed, who you have given allowance to. So not all of the healthcare providers are actually good about this, but by law they are supposed to. And you should also know that anybody who's listed on your HIPAA, basically, like if you're laying in a hospital bed and somebody, like let's say your husband is there with you, next to you in the hospital bed, the doctor comes in, your husband's listed on the HIPAA, that's great. Doctor can talk to your husband about what's going on with your healthcare. Let's say your mom is out in the hallway in the waiting room. She's not listed on your HIPAA. Your husband just spoke with the doctor. So the doctor is not allowed to speak to your mom directly about what's going on with your healthcare, but he already spoke with your husband. Your husband can go out to the hall or the waiting room and talk to your mom about what the doctor just told him. So even though they're not on your HIPAA, they can still get information. They just aren't allowed to speak with the doctors and healthcare providers directly. In order to do a HIPAA, you just need the name, addresses, and phone numbers for people who you want to put on that list. And most healthcare providers, hospitals have their own HIPAA document that you can fill out if you're going in for a procedure. Okay, medical power of attorney. This is one of the really important documents that everybody should have. You are appointing somebody to make legal decisions for you when you cannot make them yourself, for anything relating to healthcare needs. So if you are in the hospital and you're unconscious and the doctor says, hey, we need to give Angie the surgery, can we give Angie the surgery? Whoever is listed as Angie's medical power of attorney will be able to say, yes, please give Angie the surgery. Now, if Angie doesn't have a medical power of attorney and Angie can't answer the doctor herself because she's unconscious, the doctor has nobody to give authority to him to give her the surgery. And that is when a guardian would need to be appointed by the court. So I have a statutory form here. I'm just going to show it to you really quickly. This is from the hhs.texas.gov website. You don't need an attorney to fill this out. You can go and download it, fill it out yourself, and just, get it notarized before a notary public, which you can find notary publics at any UPS, at your bank. I'll notarize it for you if you want. Send me a message and I will come and notarize it for you. I think it is so important for everybody to have one of these documents. So it's very basic. You just, I insert your name, appoint, and then you put whoever you want. Usually, someone you trust. a spouse, a family member, adult child. So you list their name, their address, and their phone number, and then they become your agent to make all healthcare decisions for you if you can't make them yourself. You can also name alternates in case your first named person isn't able to make decisions for you or doesn't want to. We usually leave this duration part blank, this date, because you don't, that puts a limit on the amount of like when the agent can make decisions for you. And we don't usually want to limit that, only if you revoke it. These are all things you should read, but essentially you just sign before you notary public. The notary puts their name, their signature, their stamp. You could also get 2 witnesses to sign for you if you don't have a notary, but it's easy to find a notary, so I usually recommend to just get a notary if you can. And again, if you need a notary, UPS, your bank, call me, I will come and notarize the document for you. So that's the medical power of attorney, very important to have. Next one is the durable power of attorney. So again, this has to do with finances, whereas the medical power of attorney has to do with your healthcare and decisions about your body. The durable power of attorney has to do with your bank accounts, your real estate transactions, your stocks, your bonds, your taxes, any litigation claims, government benefits, anything like that, insurance. It all is taken care of by your durable power of attorney. So again, there's a statutory form here. Show it to you really quickly. This is again from the hhs.texas.gov site, and it just takes you to a Word document that you can open up, and you just put in your name and you put in the name of an address of the person you want to appoint. All these powers that you see here listed, A through N, are all the powers that your power of attorney are going to have over your finances if you can't make these decisions yourself. If you are comfortable naming your power of attorney and giving them all of these powers, you can initial just once next to this last section O. If you're not comfortable giving your durable power of attorney all of these powers, you should really reconsider who you're naming as your power of attorney. Somebody is going to have to make these decisions if you can't. Obviously, I know for me, when I had to name a durable power of attorney, it's difficult because it's a big responsibility. But if you can't do it yourself, someone has to make these decisions, and all of these decisions are very important. So pick somebody, the best person that you know of that you trust, and give them all the powers, because somebody's going to have to do it one way or the other. And if you don't pick somebody, the judge will pick somebody for you. Other things that you can choose here have to do with, whether you want to offer your durable power of attorney compensation payment for doing the job while they're doing the job. They don't have to accept it. They will be taxed on it. They will have to keep track of their time if they accept compensation. You don't have to offer them compensation. You could just say, no, you know what? It's part of the job as being one of my family members. You only get reimbursement for out-of-pocket expenses. That's fine. You can name co-agents. So 2 people, if you have, say, a lot of people choose co-agents when they have more than one adult child and they don't want to pick a favorite, quote unquote. So they name both their kids or all 3 of their kids to act as co-agents. The issue that I personally have naming co-agents is that one person is always really going to be doing most of the work. So it doesn't really make sense to me to name co-agents. But if you do end up naming co-agents, you can choose whether they can act independently. Like, so if you have 2, whether one can sign by him or herself without the second person, or if they have to all act jointly, or if there is more than 2, if there's a majority that would be needed for them to make a decision. This last issue here has to do with the ability for your durable power of attorney to make gifts from your estate. In other words, just give money away to, usually it's for the purpose of making your estate small enough that it's not going to be taxed if you die. But right now the federal taxation limit is very high. So the chances of you needing to do that are slim. And then the last decision you have to make on this durable power of attorney is right here. It's when your durable power of attorney takes effect. And the question really becomes whether you want to have 2 doctors giving a note, essentially saying that you are actually disabled, that you are incapacitated, that you can't make financial decisions for yourself. If you get 2 doctors to sign off on your incapacity before the durable power of attorney steps in, you have that option. Or you don't need to get 2 doctors' notes, and the durable power of attorney can step in at any time as soon as you sign it, technically, but hopefully will not abuse the power and will only actually step in when they are needed. So again, you need to get this, you need to sign and you need to notarize it. Here's some more definitions about stuff for your agent. And you can also list successors in addition to your primary person. So again, you don't need an attorney to fill this out. Please go to the hhs.texas.gov website. If you do not currently have a medical power of attorney or a durable power of attorney, download these forms, fill them out. I will notarize them for you, but have it in your records so that you don't ever have to have a judge appoint anybody for you. Declaration of guardian.
Hi,
Again,
Stephanie.
Yes.
Just thought to check. Can everybody hear Stephanie pretty well? And I did launch the closed captioning in case that helps.
I'm sorry, is it kind of not?
No, once in a while it fades in and out, but
Hmm.
overall it's pretty good. I just thought to just check with the group if everyone's good.
Okay, thanks, Mark. Yeah, if anybody can't hear or has an issue, please raise your hand or put something in the chat or whatever. Okay.
And everyone has those PDFs that, yeah, perfect. Okay.
Great. Yeah, so Mark kindly sent out the PDFs in the email as attachments. So you don't even need to go to the hhs.texas.gov website. You can just open it right on your email, fill them out, get them notarized, have them, with you. There's such important documents to have. And I can tell you a lot of horror stories, but I don't want to scare you. So I won't. But you do want to have those in case anything should happen. This declaration of guardian, again, is just a backup for the powers of attorney, which this is something that most estate planners will do for you. It's not something you can download, but again, if you have the powers of attorney, then hopefully you won't need this backup document. The Advanced Healthcare Directive, which is known in some states as a living will, this has to do with end-of-life decisions, so i.e. pulling the plug. I don't know if any of you remember the Terry Schiavo case. She was in a coma for a very long time, and her parents and her husband were fighting over whether they should pull the plug. This was like back in the 90s, I think. And it really brought to light the importance of advanced healthcare directives because the court at the time was trying to decide who should have the authority to make the end-of-life decision for this poor woman, if they should listen to her husband who wanted to pull the plug, or listen to her parents who did not want to pull the plug. So having an advanced healthcare directive, it really it appoints somebody to make those decisions for you, and it also gives your wishes so that people know what it is that you want. This, again, is a statutory form that you should have. If you don't have it, again, you can go to the hhs.texas.gov website and pull it up. I'm just going to show it to you because it's here, and sometimes people get confused by this one. So, again, put in your name. This first set of options has to do with, okay, let's say you're given a 6-month terminal diagnosis. The doctors say you have 6 months to live. You are, incapacitated. You're not able to communicate your wishes. And they're asking, do you want to be taken off of life support, or do you not want to be taken off life support? If you do want to be taken off life support, you initial next to this first option. If you don't want to be taken off life support, you initial next to the second option. In the second set of choices, it's a similar situation, except rather than being in a terminal diagnosis situation, you're in an irreversible condition, which means you may not die from it, but you're unlikely to get better. So I usually say, if you're in a coma, you may not die from being in a coma, but the doctors are saying you're not going to come out of it. It's been a while and it's time to make this decision. So again, if you want to be taken off life support, you initial next to this first option. If you want to be kept on life support for as long as possible, you initial next to the second option. Oops, sorry. The second page, you can list any specific instructions that you have regarding end-of-life decisions. If you want your body to be donated to science, if you don't want to ever starve to death, if you want to be put on a respirator, if you have COVID, those types of things, anything specific you can write in there. Again, you can get it notarized, or you can have witnesses sign this for you. So that's the third important document to have. All right, so we went through all of the disability documents. The three main ones that you need, obviously, are the medical power of attorney, the durable power of attorney, and the advanced healthcare directive. For anybody who is a young adult, you should also have a HIPAA. You should have a HIPAA even if you're not a young adult, but especially young adults should have a HIPAA. I just put this life cycle of adulting slide in here because I feel like for all of us, we kind of go through different phases. When you turn 18, when you actually become a legal adult, the first step of adulting, what it means to be an adult, really is to take care of yourself. Nobody else, just yourself, and nobody else is going to actually take care of you. I had to have this conversation with my brother-in-law, who is, 24? But he acts like a 16-year-old. And we were on a vacation in a cabin to ski with all of my husband's cousins who are around our age. And Steve obviously is the youngest at 24. And everybody's, we're getting ready, we're cleaning up, we're doing the dishes, we're packing up. And he's sitting there playing a video game, like not paying attention to what anybody is doing. And I'm looking at him going, Steve, I love you. You notice everybody else is like packing, getting ready to go, cleaning up, and you're sitting here playing video games. Are you packed? No. Okay, well, maybe you should think about getting that stuff done first before you play your video games, because, we got to be out of here by a certain time. I'm like, you're an adult now. You're 24. Nobody is going to take care of you because you should be able to do it yourself. The first step to adulting is taking care of yourself. As we get older, as I'm sure most of you know, we just add on to the responsibilities. Now we're not just responsible for ourselves. We have to be responsible for other people, like a spouse. Everybody knows your husband, he doesn't take care of himself. He's not an adult. He relies on you to help take care of him because women do all the work, let's just face it. So when you get married, not only are you taking care of yourself, you're also taking care of your partner, your spouse, usually your husband. When you become a parent, oh Lord, then you're taking care of a little human being who absolutely relies 100% on you for all of their needs. When you're parenting an adult, you're still probably taking care of your adult children. Maybe not as much as you once had to, but you also need to make sure that they are prepared to take care of themselves, which can be a whole other challenge, I'm sure, as my mother has told me. My mother also is now at the age where she's taking care of her parents. So, they're in their 90s, they have Alzheimer's, they need full-time care. It's a lot of work. So making sure that, your parents have somebody who's going to be there taking care of them is another job. And then when you yourself are, I don't want to say elderly because retirement is not necessarily an old age, but when you have lived your life, you've done your work, you've put in your time, and now you're actually able to enjoy the fruits of your labor, what most people call the golden years. Just making sure you have all your ducks in a row. I know we all get busy, we all have things that come up, but making sure that, oh, now that I have maybe some time to really look at these things, make sure that someone has been appointed as your power of attorney to take care of you if something should ever happen. We'd love for it to happen at age 18, but things change. Making sure that your documents are updated are really important too. Making sure that it hasn't been 20 years since you last looked at your medical power of attorney, and the person you originally named, who may have been your mom or your dad at 18, right? And maybe they're not able to be your power of attorney anymore. Maybe it should be your friend or your spouse or your sibling who's an adult. So making sure those things are updated, and just really making sure that you are taking care, again, going kind of back to the stage one, taking care of yourself. It's the first step. There are a lot of other steps that come after that, but making sure that you are taking care of yourself is point number one. And that's pretty much it. I think I have a few minutes for questions if anybody has questions. Thank you guys for listening. I do free consultations if anybody has any questions, but again, for disability documents, you do not need an attorney to fill these out. So please, if you don't have them, fill them out. All right. So if anybody has questions, you can feel free to come off mute.
I have a question.
Mm-hmm.
The durable power of attorney, can that also works while you can make decisions for yourself? Like, for example, I am out of the country, but my spouse needs to sign papers for me. Is that the same? Is that where durable power of attorney can come in? Like, I'm overseas because I'm attending a funeral or something in a different country, and then my husband's here in the US. Can he sign papers with that durable power of attorney?
So it would depend on whether on which option you chose with regard to when the durable power of attorney takes effect. If you said that you have to get the 2 doctor's notes before the durable power of attorney can step in, then no, your husband wouldn't be able to sign on your behalf if you were still competent to make those decisions yourself. If you said he can sign without the 2 doctor's notes, the power can come immediately, then yes, he absolutely can sign at any time for you when needed. I will say that in this day and age, they have made it a lot easier to sign documents even when you're overseas. So if you are out of the country and you need to have something signed, they have, Texas especially is really good at this. They allow for online mobile notarization. So you can just get online and have something notarized, even if you're not in the United States. As long as you're a US citizen, and you have a social security number, you can get anything notarized. You can go to an apostille, you can go to the embassy. It's not always the most convenient, but there are definitely ways if you have capacity to still sign things, legal documents, even if you're not in the country. But if that was a concern, I would definitely make sure that you chose for your power of attorney to not have to get the 2 doctor's notes, that they would be able to step in immediately upon your signing.
Cool, thank you.
Mm-hmm. And yes, disability documents take effect while you are still alive, but disabled. So a lot of people think, oh, well, if I'm dead, what does it matter? Disability documents, once you pass away, are no longer effective. So if you have a durable power of attorney, like if you have Alzheimer's, right, and somebody's been acting as your durable power of attorney, once the person with Alzheimer's dies, the durable power of attorney no longer is good. Then you have to do a will or a revocable living trust to act on that dead person's behalf. So they're completely different things. And wills and trusts, even though they are extremely important, they're a lot more complicated. So if you have any questions about that, I'm happy to answer them, but it just gets more complicated, which is why we were talking about this today in the time that we have. Does anybody else have any questions?
I have a couple more questions unless somebody else has some.
Go ahead, Emlyn.
To be considered incapable of making your own decisions, that is a physician that makes that decision?
So when you are declared incompetent, usually, like if a court is saying they need proof that you are incompetent, yes, typically that they will require a physician, 2 physicians actually, to state that you don't have capacity. But each state has different check marks for what counts as you having capacity. And it depends for different things. Like there's capacity for being able to represent or to participate in like a criminal hearing. There's that kind of capacity. There's capacity for just being able to make medical decisions, which could be different from your capacity to give testimony at a hearing. So it kind of, it would depend on what exactly you mean by capacity, because for what purpose. But when we're talking just about medical powers of attorney and durable powers of attorney, the question really is, do you know who you are? Do you know how important these decisions, like what it is that you're making a decision about? So like whenever we have somebody signing a will, I have to make sure that they know who they are, they know what a will is, they know what their will says before I can let them actually sign it. Because if they don't know those things, they don't have capacity to sign, I can't let them sign. They would need to have a durable power of attorney or somebody else who's legally competent sign for them. So anyway, thanks everybody. I think we can go into our networking breakout rooms if everyone's ready for that.